CR 2127, State of Texas versus Hannah Marie Smith. Do I have parties announced for the record for the state?
Brian Bremer for the state of Texas.
For the defense?
Monica Guerrero for Ms. Smith.
All right, defense has filed a motion asking that the defendant's bond be reinstated. State, are you ready to proceed?
Yes, Judge.
Just so we're clear, some things happened. I think I remember this. Ms. Smith was not supposed to be driving. Ms. Smith, I believe, was behaving inappropriately and was asked to come to court. The court had no idea that Ms. Smith had been driving for who knows how long. And Ms. Smith drove to court, but she was in a vehicle on Zoom, and then she drove to court. So that's where we are. So Ms. Herrera.
And on that day that she came to court, apparently her retained attorney withdrew. And then I was appointed to represent her.
Yes.
So I haven't had this case very long. However, the court remanded her without bond on that day, and she's been in custody since. Her family is extremely supportive. They sold her vehicle so she wouldn't have a car anymore. Her employers contacted me. Her boyfriend's contacted me. Civic leaders have contacted me. Her mother has contacted me. They all want her to get back out so that she can go back to work and show the court what she's done. She's been in 12-step programs. She has not had any positive UAs. She tells me that, you know, she's been doing everything that the court has asked her to do, and that she was unaware that Ms. Corley had filed an affidavit of non-driving. She had been blowing into an in-home device, and she would like very much to be placed with a bond so that her family can make her bond. That if she has a vehicle, that she will put ignition interlock in there. But as of right now, her mother has told me they have sold the vehicle and they no longer have anything for her to drive. Her bond was set at $50,000 in inception.
Well, even though Ms. Corley did an affidavit of non-driving, people in this court who are on DWI, I always let them know and have them present when someone is doing an affidavit of non-driving, because I tell everyone that they need ignition interlock, and they say, oh, they're not driving. And I say, well, they need to provide an affidavit of non-driving. My concern is she filed an affidavit of non-driving. Obviously, her signature is on it because it's an affidavit of non-driving, and yet she drove to court and she didn't have ignition interlock.
Judge, if I may, obviously, Judge, I was going to bring up my recollection of that day was the same as yours. I did want you to take judicial notice. I know you were on the Zoom that day. You know, if there is an affidavit of non-driving on file, I mean, I presume that she signed it and that, you know, she was aware that she wasn't supposed to be driving. Regarding the indictment in this case, it's a very serious charge, among the most serious charges you can get involving a vehicle. And that's why we believe it's important, Judge, to not take it lightly, the fact that she said she wasn't driving and then she was for sure driving that day that we see her on Zoom driving. We can presume that she was driving on other days if she thought she was just free to drive. The state would ask for her bond, if you grant her a bond, for it to be doubled to $100,000 along with full GPS house arrest.
I'm still trying to figure out, why should I grant her a bond when and mind you, Ms. Smith, I don't take any of the facts of these cases true because I haven't heard any facts. But what I have is you're charged with intoxication manslaughter. You did an affidavit saying that you would not be driving, and yet you were driving, which means you were driving without ignition interlock, and you're charged with intoxication manslaughter. The number one rule when you have any intoxication offense, if you're doing an affidavit of non-driving, you don't drive. If you're driving, you have to have you have to have ignition interlock. So I'm not going to reinstate the bond. You're remanded without bond.
I'm sorry, I forgot that I had signed the paper and wasn't driving for that long. I'm really, really sorry. I have been doing so good. and I want to continue to do good.
But you knew you were driving without ignition interlock. But if you want to give testimony, I will swear you in. You want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
You can lower your hand, state your name for the record.
Hannah Marie Smith.
All right, Ms. Farrell, do you want to do question and answer, or you just want her to state?
I just want her to talk.
All right,
I did not, I was not aware. I do remember signing the paper, but I was not aware that I was not supposed to be driving at all. I did tell Miss Linda Corley, I called and I had spoke to Roland. And I had told Roland, he didn't tell me anything about getting the interlock or calling pretrial. There's something about I was supposed to have called pretrial. I was never told any of that. I would have done it. I have done everything that I have been told to do. I would have done it. I'm in IOP, I'm in precision recovery. I went to an inpatient program. I have a sponsor. I worked a 12-step program. I go to AA meetings. I go to see Rick Green regularly Tuesday and Thursday night. I fully participate. I'm on back on my mental health medication. Being in the IOP program has put me, I have found out that I have hyperthyroid and Graves' disease, which I wasn't aware of until I had gone into the IOP program. I mentally, physically, everything about me has gotten so much better. This past year to year and a half, I'm really sorry. The car is gone. You get to take my license. You can revoke my license. You can do whatever. I'm not going to drive anymore. I take the bus. I'm trying. I tried really hard for a whole year. I'm sorry.
state, any questions?
Nothing specific, Judge. I would just like the court to be aware, or just obviously, Judge, I mean, I think it's concerning that she's signing things, and the biggest concern we have whenever someone commits a crime with their vehicle is they're going to do it again, and she's not even aware of conditions that are part of her probation, or I'm sorry, part of her pretrial.
All right, and the court notes that there is a previous pretrial violation, Ms. Terrell, for high-draft reading, but at that time, the court did not issue a judge's warrant or remand her without bond. But you knew you were not supposed to be driving, and yet you did it anyway. And you drove without ignition interlock. And again, we go back to the fact, I don't take it as true, but you're charged with intoxication manslaughter. So the motion to reinstate the bond is denied.
Will the court consider any bond?
Not at this time. If you want to speak with the state and see if the state would be in agreement for a bond, but at this time, no. Ms. Ferguson, this is, the setting date on this is May 16th. Ms.
Correct,
Ferrell.
it's next week.
Okay.
It's calling 2025 CR 004-104. State versus Eduardo Hernandez III. Can I have parties announced?
Rick Pena for the state of Texas.
Doug Campbell for Mr. Hernandez.
All right, if y'all could not talk behind the court reporter while we're on the record. And are you Mr. Hernandez?
Yes.
Counsel, you received all discovery. Did you review it with your client?
Yes, Judge.
Mr. Hernandez, did you review the application for deferred adjudication with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney?
Yes.
Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Hernandez, did you review the court's admonishments with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with injury to a child or elderly or disabled person, bodily injury as a third-degree felony? Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine? You need to speak up.
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Hernandez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Excuse me, miss, if you cannot whisper, then you need to stop talking. We're on the record. All right. Are you a U.S. citizen?
Yes.
Has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $1,500 fine. State recommends deferred adjudication. They're taking in consideration 2025 CR 003443. There's an affirmative finding of family violence. There's to be no contact with the complainant. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, ma'am.
Did you understand that to be the entirety of the plea?
Yes, ma'am.
Defense is that the plea?
It is.
State is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 2 years. There be 80 hours of community service restitution, a MIC evaluation, follow the recommendations from MIC, a TAP evaluation, follow all recommendations in anger management. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Yes, Your Honor. This time, state offers into evidence State Exhibit 1 with all attachments.
No objection.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. And state, have you spoken to the complainant?
Yes, we have, Your Honor.
All right. And then the complainant's name is listed with the last name of Garza in the police reports. But in the plea bargain agreement, you've put it as Hernandez.
Judge, it's his stepmother. I'm not opposed to it. If the court needs to make a change. We're not.
All right.
You're right. I'm sorry.
Well, actually, they have two. They have one that's Hernandez and one that's Garza. And they have two completely different birth dates. So I'm assuming it's no contact with both. Because one is listed as January, one is listed as October
I think it's.
in the stipulations.
It is Garza.
It should be Garza with the January 10th, 1959.
Okay,
I think the other one might be a typo.
all right. Love typo, gotta love typos. All right, thank you, State. You may be excused. After reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
Yes, Mr. Hernandez is going to be homeless because of this incident. While he wants to take responsibility and get this behind him, he's not going to have a job. He's not going to have any money. He would like some assistance in finding a house, but if that's possible to any of the services the court might have available to it. He also would like to have it probated, the fine, and he'd like to do his evaluations while out in the world.
All right, so why didn't you clean up your mess in the kitchen? Yeah, that's what it says. It said they told you to clean up your mess in the kitchen. You became upset and said something bad was going to happen and you will not like it. That's what you told the complainant. So how old are you?
I am 39.
Why are you living with your parents anyway?
I got kicked out of my other parents' house. And I lost my job too.
All right, so why did the other parent kick you out of their house?
They got upset. They're arguing about something about a bowl. That's my boss. It's just
Something about what?
a bowl, a cereal bowl.
Mhm.
And they're just got an argument.
All right, so here's the thing. You're an adult. You shouldn't be going from parents' house to parents' house. And I'm going to tell you what I tell everybody who is an adult or living with somebody else. If you want to keep a dirty kitchen, you can keep a dirty kitchen. But guess what? It needs to be your dirty kitchen. So whether you're an adult or not, whether you're 21 or 60, if you're living under somebody else's roof, you need to follow their rules. You understand? They're asking for a MIC evaluation. Is there any prior mental health issues?
That's my nephew.
I'm sorry?
He has physical deformity, Judge. He can't hear out of his left ear.
Oh, okay.
So you might have to speak up a little.
All right. They're asking for mental health evaluation. Have you ever had any mental health diagnosis?
No.
All right. So do you have any children?
No.
This is what the court is going to do. 3 years deferred adjudication, regular reporting by Zoom or in person, regular random UAs, taking consideration 2025 CR 003443, $1,500 fine, probated, affirmative finding of family violence. There's to be no contact with the complainant and no contact with the complainant's address, which is on Larkia, Larkia Lane. So don't be on that street, you understand?
Yes, ma'am.
Proof of employment within 30 days. There's to be no employment as a home healthcare provider or with minors. Field visits 1 time per month until further notice. 100 hours of community service restitution. TAP evaluation, that can be out of custody. Follow recommendations. And they're asking for a MIC evaluation. I'll go ahead and do one. MIC evaluation out of custody. And I'm going to order anger management classes and a life skills course. The court will give him 50 hours credit for completion of the anger management class towards his community service restitution, and another 50 hours credit once the life skills course is completed. Probation, is there anything else? Is there anything else you need from the court in order to be successful?
No, ma'am.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did
Yes,
you
ma'am.
understand it? And
ma'am.
did you?
What do you think about this courtroom moment? The judge's questions and the defendant's answers reveal how serious the situation can become inside a courtroom. Every statement matters, and the judge has to carefully consider the facts, evidence, and arguments before making a decision. This case shows why courtroom proceedings can be so intense and unpredictable. One answer can raise new questions, while one piece of evidence can change the entire direction of a case. What's your opinion on this case? Let us know in the comments. If you enjoyed this courtroom breakdown, make sure to like, subscribe, and turn on notifications for more real courtroom moments and legal analysis.